So, conditional legislation is a kind of original legislation. So, every conditional legislation is made by the competent legislative body, that is the parliament in case of England and India, and in case of United States of America, that is the Congress. And these conditional legislations are always complete and full, so there is no question of any delegation of making any rules, regulations, or circulars or bylaws. And this kind of conditional legislation is being recognized both in pre-independent India, so also in post-independent India. So in pre-independent India, it was held as operative and valid in the leading case Queen versus Broch in 1878. So also in post-independent India, our Supreme Court held the validity and operation of conditional legislation in the leading case A.K.Ray versus Union of India in 1982. And there are certain different forms regarding conditional legislation. As already we have discussed, conditional legislation is always made by the competent legislative body, either parliament or Congress. So it is always complete and full. But in which manner, in which way it will come into effect, that is called condition or contingent to that legislation. So regarding that, the executive or administrative authority has certain discretionary powers, like the very date of commencement of that legislation, and regarding to extend its life or the period of its operation, and to extend the very operation of that legislation to more territories within that state. So also it can be extended to more objects. So regarding the very date of commencement, we could discuss that in 2019, the Citizenship Amendment Act was enacted by our parliament, but the very date of commencement is left to the executive, and the executive implemented, or the date of commencement came only in April 2024. So also to extend its life, suppose the very conditional legislation is to last to a specific period, then the very duration of its operation could be extended by the executive or administrative authorities. So also to extend to more territory, that is regarding, suppose the very act is operative to certain states. For example, any act enacted by the Parliament of India, suppose it is only operative to certain states in the northeastern areas, such as regarding Assam, Tripura, Meghalaya, Manipur, Mizoram, and it could be extended by the executive to Arunachal Pradesh. So this kind of extending to more territories falling under conditional legislation. So also the very extending the jurisdiction of conditional legislation to more objects, as under certain acts there are certain categories of objects, like in the Drug and Magic Act, certain diseases are included. So also the executive has the power under conditional legislation to include any more such contagious diseases within that conditional legislation. So, in that case, we found an important leading case, that is Hamdard Dawakhana versus Union of India in 1960. The Supreme Court clearly recognized the very difference between conditional legislation and delegated legislation, and it also, like the pre-independent India, in post-independent India, it upheld and acknowledged the very position of conditional legislation.